Citizens for Fair Representation. And what we hope to do is to ask the county to join a lawsuit brought by Citizens for Fair Representation in order to sue the state of California for lack of representation and dilution of vote.
So before you go further, I just want to make sure that the public knows and the board is aware this is an informational item only.
That's correct, informational only. I would ask that this be put on the following agenda for a vote if that's possible, or whatever process is required in order to do that. I'm willing to go through. But this is information only. I guess I first want to say that why do we need to do this? Why do we need to sue the state of California? By the way, this has nothing to do with splitting the state. It has nothing to do with the state of Jefferson. This lawsuit is being brought in order to gain more representation for all counties of California, and rural counties lack representation specifically, and so in order to foster that change, we have to sue the state because they're not going to do this on their own. The state of California was formed with a specific goal in mind. And the founders of the state of California, they outlined that reason to form the state in the preamble to the Constitution. We, the people of the state of California, grateful to Almighty God for our freedom, that to secure and perpetuate its blessings, we formed this Constitution. We formed the state of California in order to perpetuate liberty and to secure its future in this state for the people of this state. And we did that with a certain foundation according to the Constitution originally in 1849 and again in 1879. And in the Constitution of 1849, the metrics then were for each county had a state senator. Historically, there's a question there. It is possible that San Luis Obispo County didn't have one. And we found documents in the archives in Monterey to suggest that the state senator from Santa Barbara, as he rode to Sacramento, stopped and talked to the 4 people that lived there, found out what they wanted, and then went on with their wishes. But there are also papers that document that there was perhaps a state senator in Santa Barbara County. So when the state was founded, each county, we had 10, had a state senator, and each county had at least one assembly person. And the ratio of those people were in the assembly was 1 to 2,500 people. And that stayed in effect for at least a decade and perhaps more. By 1862, the state found it inconvenient to continue to increase representation and capped the legislature at 40 state senators and 80 assembly people. And from there, the metric grew. But even in 1862, and I have those papers here, I just can't remember what they say, it was around, I think it was around 5,000 per in 1862, but I can dig that out in a minute if someone has a question. Anyway, and so as decades grew, representation ceased to grow. In 1862, we were capped by in the California legislature, and we have found documents in the archives in Monterey that the reason that cap was put in place is to ensure that a growing Chinese population would not gain representation in effect to gain majority over the state of California. So this, we believe that this was done prejudicially to begin with, but nevertheless, here we are now. And in fact, the first Asian American to gain a seat in the California legislature was Marge Fong Yu. And so it was very successful for a century. Well, that brings us to where we are now. And where we are now is that our state is guaranteed a Republican form of government by Article 4, Section 4 of the United States Constitution. We no longer, we now have a pure democracy as a result of several court cases, and some of you have already heard this, but it started with Baird versus Carr, where the federal government gave themselves permission to intervene in state election processes. And it went on with Gray versus Sanders, where the court said that each person has to, they created the principle of one man, one vote. Now that doesn't mean one man, one vote per se, because everybody's always had a vote. In fact, we have amendments to the Constitution to guarantee that women have votes, that people over 18 years old have votes, that minorities have equal access to votes. By one man, one vote, I mean that in Gray versus Sanders, the federal court decided to change the way 30 states did business electing state officers by mandating that both houses of a bicameral legislature, and indeed any house that has a unicameral legislature, their districts must be approximately equal in population, and all state officers will be elected through that process. And then, and Earl Warren said that during Gray versus Sanders that he was doing this to ensure that any mistakes he made during Baker versus Carr were corrected, and that states would be afraid to act prejudicially because they'd be afraid of federal court action. Something like 20 court challenges later, contrary to Earl Warren's view, he decided to put a nail in the box in the case called Reynolds versus Sims. And there he declared that all state elections will be conducted by schemes supervised by the federal court and subject to federal court jurisdiction. That not only was the end of state sovereignty, but it was also the end of effective representation for states within the union, and particularly for states like California. The dissenting justice in Gray said that if we do this, we'll create a nation that has an entirely city point of view, and he was absolutely right. And in fact, there are 2 or 3 states that could effectively control all election cycles in the United States if it were not for the Electoral College. That's the only check that we have left there. However, the United States itself enjoys something called the federal model of government, or the Connecticut Compromise, where each state has two United States senators, and then the lower house is elected by apportionment. And that's the way it was in California in the beginning. And as California traveled away from that model of government with cap and representation, then we came to 1928, where even the people of California saw that this wasn't going well, and they were joined by urbanites as well. And in an initiative called Prop 28 in 1926, authored by California Farm Bureau Federation, and it was passed by a vast majority popular vote and survived 5 challenges by initiative with overwhelming majorities to maintain that system. California went back to a model where roughly we had 1 state senator for each county. Now that wasn't quite true because there were counties like Alpine that had so few people and so few county mechanisms that they really didn't even qualify, quite frankly, still don't, as counties. And so in those situations, Sierra County, Plumas County, places like that, a state senator was allowed to share 3 counties, but no more than 3, and they had to be contiguous. And then assembly members were elected by popular vote, as they are now in apportionment districts. So once we got to 1964 and through Baker and then Gray and then Reynolds, Chief Justice Earl Warren changed the way 30 states elected state officials. And we now have a situation in California and in all 50 states where one house of government is simply a rubber stamp for the other, because they're all elected by apportionment schemes that are similar. Some have different memberships. For example, in California, we have 1 state senator for approximately 1 million people and 1 assembly person for approximately 500,000 people. And so the only way to change that metric is through federal court again. Because in our view, Citizens for Fair Representation, we find that rural counties are terribly underrepresented. First of all, a state senator cannot possibly adequately represent 1 million people. A state senator that's shared by 11 counties, often who have competing interests, is an utter failure as a political model. And I think we've seen that in rural counties. I'd like to ask you in the question period, what metrics in this county are up? What lines are up? Employment, jobs, wages, real wages, retention of skilled population, forest activity, grazing, farming, ranching, water rights, property rights. Are any of those lines up? Are any of those things trending towards better? I don't think they are. In fact, I just had to go get a job. I had to leave the state to get a job. I'm flying one of the air tankers the guy was complaining about. $5.45 a gallon. That's how much it costs. But anyway, and so we decided, we went to 21 counties and we asked them, in order to cure our representation problem, would you join with us in trying to separate from the state of California so that we can form a government that adequately represents the people? 21 counties agreed that that was a good idea. We submitted those questions to the state legislature and the silence was deafening. We heard nothing from them, nothing whatsoever. And so our next action is to bring suit against the state of California on behalf of all Californians. And by the way, the counties that we've heard from lately are Merced, Kings, Fresno, San Bernardino, Riverside County. People in the Inland Empire don't have representation either. People in Kings County don't have representation. We have political parties that have agreed to be plaintiffs in the lawsuit. The American Independent Party has agreed to become a plaintiff. Because if you take the total of their membership, and if you took all of those people and put them in one district so that they could hope to gain a seat in the legislature, they still couldn't win the election because the district's too big. We're petitioning the Green Party to be part of the lawsuit. They don't have representation. They have 44,000 members. They couldn't win a seat in the legislature if everyone lived in the same town because they physically would not possess enough votes to gain a majority even for one seat in the legislature. We have a county sheriff that's joined the suit. We have county supervisors. Supervisor Wall from Butte County has joined the suit. Sheriff D'Agostini has joined the suit from El Dorado County. We have individuals. We have two tribes, the Shasta Nation and the Pit River tribe have representatives that are plaintiffs in the lawsuit now. And here's what we need. We need a county government as a plaintiff. We're talking to Glenn County, Colusa County, Lassen County, and Siskiyou County. But here's our problem. We need to file this lawsuit now. And in order to do that, we need a county government to join us. What will the lawsuit accomplish? In other words, why are we doing this? The lawsuit will not accomplish a state split. We're not asking for it to. That's not part of the end game in this. What we're asking for is representation adequate to our needs in this county and every other county. What form will that take? That's up to the court. But the form that we hope it will take, one of the plaintiffs, potential plaintiffs, Glenn County, they hope for a state senator for each and every county, equal representation in the state senate, and they would like to see the assembly ratio at not less than 1 for 30,000 people. However, no county should have less than one representative in the assembly, because as you well know, revenue bills issue from the lower house. And so if you're taxed as a legal subdivision of the state, you should have representation to say how that money's spent. Earl Warren made one big mistake in Reynolds that manifests itself now. He claimed that counties were not entitled to a federal model of government or a Connecticut compromise type of government because counties were merely political arms of the state. Well, even though Earl Warren was the governor of California and the attorney general of California, he obviously never read the California Constitution. Because Article 11, Section 1 says counties are legal subdivisions of the state. The county of Siskiyou has a legal description. It requires 2/3 majority of the electorate within this county in order to change the county seat, alter its borders, and do things that would affect a legal subdivision of the state of California. You do deserve representation. You are a legal subdivision. Your representative should reside in the Senate, because that's the place where you can affect change most readily. Our representatives should reside in the assembly. I personally am a plaintiff in the lawsuit. My demand is for one assembly person for every 2,500 people. That's what we had when this state was formed. Several states still have much that same ratio. Vermont and New Hampshire come to mind. New Hampshire has a little over 1 million people. They have 400 members in their lower chamber. Their rate is about 1 for 3,200 people right now. Political campaigns depend upon this. The average money spent, and I have that metric as well, if you want to ask a question, I can read those figures to you. Money spent in New Hampshire for a political campaign are roughly $1,100 per candidate for the winner, and between $900 and $1,100 per candidate for the loser. So, and their rated incumbent turnover is around 40%, 38 to 40%. In California, we almost never lose an incumbent. It's too expensive. No one can afford to run. One of our plaintiffs is a candidate for California State Senate who ran against a guy that never spent a cent because he didn't have to. But this candidate had to get naming statements because no one knows him. He doesn't have the name recognition of an incumbent. And in order to pay for the naming statements, he had to travel to 11 counties and he had to spend $11,000 just to get himself on the ballot so that someone would know he's a IT guy or whatever his statement was. We chose not to spend that money because he didn't have it. And of course, even without that, he did get 14% of the vote, but he was never going to win. We have a former assemblyman, Tim Donnelly, has written an affidavit for the case and will be a witness in the case. And Tim says that he was a representative of 2 counties, and he often very distinctly had to fail to represent the one in order to represent the other because they have competing interests. We'll take that in our districts. Bryan Daly has, 6 or 7 counties, and shares a county, I think, 7?
10 or 11.
Yeah, okay. And so in light of that, if the county of Siskiyou has a competing interest with, say, 2 or 3 of the other counties, he would have to significantly fail to represent us in order to represent the other. And that applies also to Senate District 1 and many other districts in California. In addition to that, when you squint and look forward 50 years, 100 years down the road, you can see that in order to supply representation at the stated ratios that we'll have in the state of California with the 40 and 80 cap, it is consistent with my belief that 100 years from now, we may have a situation where 5 counties have 115 representatives and the other 53 have 5. Because urban areas grow faster than rural areas, they just do. So what we need is a check and a balance. And the way to restore that is with counties having equal representation in the California Senate, and then a much smaller district so that challengers can not only afford to win races, but they have a hope of winning those races. And can you imagine if we had an assembly district where it was 1 for 10,000, say, 1 for 20,000, just pick a number, not 1 for 500,000, no. Can you imagine how much easier it would be to go to convince your neighbors that you would do a better job than the incumbent is doing for you now? And that's not possible. In other words, if we had, say, 1 for 5,000, we would have representation in Siskiyou County where Scott Valley would have its own assembly person. If you weren't doing a good job, it would be glaringly apparent to your neighbors, and it would be really easy for them to get rid of you. And that's what we need in order to have better government and more responsive government.
Amen.
So we've got the lawsuit that we need to file. Now, why do we need the county as a plaintiff? We need the county as a plaintiff for one reason and one reason only. Title 28 of the United States Code, Section 2284 says that a district court of 3 judges shall be convened when otherwise required by act of Congress or when an action is filed challenging the constitutionality of the apportionment of congressional districts or the apportionment of any statewide legislative body. A 3-judge panel shall.
Give the code again.
Yeah.
Okay, it's Title 28, 2284. And by the way, I would be very happy, and when we come to that during this next week, I'd be very happy to email that either to county council or supply packages of all this stuff to anyone that wants it. Says that a 3-judge panel shall be appointed whenever any state legislative apportionment is challenged. Now, here's the good part for us. Title 28, Section 1253 says that except as otherwise provided by law, any party may appeal to the United States Supreme Court from an order granting or denying after notice and hearing an interlocutory or permanent injunction in any civil action, suit, or proceeding required by an act of Congress to be heard and determined by a district court of 3 judges. And that's how the Abbott versus Evenwell case made it to the United States Supreme Court so quickly. They bypassed the district court. They went from federal court straight to the Supreme Court using this plan. And by the way, the Abbott, the Evenwell attorneys were the ones that supplied this information to us. Now, so we have a method of going straight to the Supreme Court because quite frankly, if we go to the 9th Circuit, it's going to add years and $1 million to the lawsuit, and we won't be able to do it. We've already raised $200,000 toward the lawsuit, and we have several large donors who are waiting until we file. They want to know that this is real. In order to get that 3-judge panel, we need a county to be a plaintiff, and we will add counties in the interlocutories after the fact as they come on board. But we must have a county because, as you know, it's easy for the court to ignore people. They ignore people all the time. But it's very difficult for a federal court to ignore a governmental body. And that's why I'm asking the county of Siskiyou to join this lawsuit as plaintiff. We do not need any money. We will not ask for any money. In fact, we will indemnify the county against any potential for recovery of fees, and our C4 is prepared to do that. We have the ability to do it, we have the money to do it. We don't want money. We just want Siskiyou County's name on the lawsuit so that we get the 3-judge panel. If we get that, because of the Abbott versus Evenwell opinion, there is a very, very good chance that we'll win. Clarence Thomas penned, in part, he penned, which was very odd, he penned a dissenting opinion to a unanimous decision. Because in Abbott versus Evenwell, Susan Evenwell sued Governor Abbott of Texas, saying that the apportionment scheme in Texas was not constitutional because it was manufactured on lines to include all people instead of all voters or something like that. And the court held unanimously that the state of Texas was not acting unconstitutionally. But Clarence Thomas, along with 3 other justices, felt strongly enough about this that he actually penned a dissent to the unanimous opinion. He said, yes, it's true Texas did not act unconstitutionally because the state can construct their apportionment schemes any way they want to. And then he went further to say, and I've got that also, and if you have questions about it, I can read to you verbatim. He went on to say, however, this court has been defending the principle of one man, one vote unsuccessfully for 50 years because no such right exists in the Constitution of the United States. And so what Clarence Thomas told us was that he is looking for another apportionment case. He's looking for a lack of representation case, and he laid out a trail of breadcrumbs how we can win the case if we bring it. We now know that because of his support from 3 other justices, we have a 4-4 split. Well, as you all know, we're about to get a new Supreme Court justice, and he is much in the Scalia model, and so we think that we would have a 5th vote there. It doesn't matter whether we win or lose in federal court, because if we win, California is going to appeal to the Supreme Court, and under Title 28, they have the right to do it. If California wins, we will appeal to the United States Supreme Court, and we have the right to do it. So this case will end up in the Supreme Court if we get that 3-judge panel. And that's why I'm asking you to join the suit. Now, do we have standing for this? Yes, we do. Baker tells us that all voters have original standing in voter dilution and apportionment cases. Counties obviously have standing where they feel that they're underrepresented. We have one plaintiff, Larry Wall, supervisor from Butte County, who is saying directly that the state of California was remiss and he lacked representation during the Oroville Dam spillway failure because the state has known about that problem for 10, 15 years and failed to act. And because that's part of the state water project and the people who receive the water are so far away, they really don't care about the maintenance, they just want to get the water. And so Larry is alleging that the state failed to represent Butte County and failed to represent the interests of Butte County directly in the Oroville Dam failure, and he's asking for more representation. Tom Donnelly is alleging that you can't represent more than one county and do it adequately. Sheriff D'Agostini is saying that the lack of resources coming from the state of California to rural areas is directly hindering public health and safety. The rest of us are saying our votes don't count, and we want more representation proportionally. My standing in the suit alleges that when I became a voter at 18 years old, and there were only 20 million people in the state of California, my vote was worth 1. And now we have 40 million people, and my vote is worth half of what it was worth before. And I allege it's worth even less than that because most 51% of the representation in the state of California lies from the Los Angeles County line to the Mexican border. So 2/3 of California has less than half the representation, 1/3 has more than half the representation, and the northern 21 counties, which represent 38% of the land mass of California, according to our numbers, 1.2 million people, have 3. So you have 40% of the state that has 3 representatives, and the other 60% has 116. That's not going to get better. They're not going to do this on their own. They're not going to see the wisdom in this and all of a sudden say, yes, you can have a senator. It's not going to happen. We're going to have to sue them. We can win this, and if we get a 3-judge panel, I can't make any guarantees, but it is extremely likely that we will win. Now, what will we win? Each party to the lawsuit is free in their resolution to make a demand. I have a sample resolution here, a draft, if you will. It's just something I pulled up. It's an open frame document. Change it to whatever you want to. I also have an attorney-client relationship form, And that form will indemnify you from any fees. Now, also in voter rights cases, the California Voting Rights Act and the Federal Voting Rights Act say that the judge cannot assess fees in those cases unless the case is deemed frivolous and without merit. If a county joins in, it cannot be judged without merit. There's no way that would happen. And even if it did happen, it'll happen in the demers. And that's the pre-trial technicality jousting. And we're prepared to indemnify the county against any possible recapture of fees, and we have the money to do it. And once again, we have several large donors who are lined up ready to give money. They just want to make sure the case gets filed first, and I don't blame them. I'm going to get more money after the case is filed. Money is not our problem. It's the political will of this county will make this happen. You led the charge with the state of Jefferson. You had the backbone when no one else did to support trying to find a way to reverse the course that this county is on, through no fault of ours, through no fault of yours. We're all here trying to do a good job. I think most of you know me. You know what I do in my off time. You know what I do when I'm at work. I'm not a time waster. I'm not a frivolous type of person. I think if we couldn't win this, I wouldn't be sitting here in front of you. So I humbly ask you for your support to pass a resolution and sign a demand. And your resolution, by the way, simply says to the Secretary of State, we don't have enough representation. These are the reasons why: logging, logging, farming, mining, water rights, and so on. And we demand that you hold immediate hearings into the lack of representation on the part of rural counties. And we also demand that you pass that information to the state legislature so they can do something about it. And every federal challenge has a three-legged stool. First, you have to ask for something. You can't have a remedy if you don't ask a question. The second thing is you have to have standing, and we do have standing, and we can prove that. And the third thing is there has to be harm. And the harm is lack of representation, and we can demonstrate, I think, physically. And you did that to the U.S. Forest Service. We have been harmed by the fact that 93% of the people tell 7% of the people how they're going to live. That's just the way it is. And then on top of the stool sits the remedy. Because if there's no remedy for the harm, then no one can help you, and that's the end of it. But the remedy for lack of representation is easy. Now, the state of California, we think, will argue that it is inconvenient for them to increase representation. We'd have to have more offices. We'd have to hire more staff. What we intend to say back to them is that's too bad. Government, according to Article 2, Section 1, all just political powers derived from the people. Government was instituted for the good of the people. So it is not an argument to say in court, it is inconvenient for us to fulfill our responsibility to the people we're supposed to serve. And I think we can prove that argument. One of the problems we have with the complaint, it's 57 pages long. I have bios for the attorneys here also, which I'll be happy to supply to all the members of the board and county council. We have one attorney who's working pro bono. He's Eugene Martin. He's won 4 cases in front of the Supreme Court in open court. And he thinks we need to cut that complaint down significantly. We have so many causes of action, and they're all good. But what he's afraid of is that the federal court will think we're throwing noodles at the wall hoping some stick. So we're going to whittle the causes of action down, and we're going to present a complaint that's around 30, 35 pages. But as soon as the county of Siskiyou decides whether they will participate or not, we're going to file. We'll file even if the county chooses not to participate. But if we don't get the 3-judge panel, you'll know why. And if we fail to get that 3-judge panel, this turns into a multi-year, multi-million-dollar deal. I would be happy to answer any questions that you have, and I thank you very much for your time. Michael?
Before we go there, I've got a couple public comments, and we'll go there first,
Sure.
and then I'll bring it back to the board. Daniel Simon, 3 minutes.
This is just public comment. So 3 minutes, basically? Okay. Well, yeah, I'm here to support what Mark Baird is doing. Oh, sorry, Daniel Simon, I live in Hornbrook. And thank you. Yes, I'm here to support this. I wanted to mention something about Massachusetts, okay? They have 160 members in their state house assembly, if you will, from 12 counties. That means 13 people per county are going to the state house in Massachusetts. When you look at Siskiyou County in land area, we are larger than Rhode Island or Delaware. When you combine us with Lassen County, we are larger in land area than the state of Massachusetts. And we have Brian Dahl for 6 counties, I believe. So we have 1/3 of a rep between the land area of Massachusetts. This is such a disparity. It's obviously, the rural counties have been deeply hurt from this chronic representation ratio. You look at New Hampshire, which he mentioned, around 3,200, the ratio of 3,200 people per one state house rep. They have a number of really good things. They call themselves the Free State, live free or die on the coin. You have no safety belts required, no helmets, car insurance is not required, and also the pinnacle of a good republic, which would be jury nullification can be introduced by the defense attorney. And so what we have here, yes, 1 per 500,000 people in the assembly. Good luck competing with 500,000 people for the attention of an assemblyman. And of course, the senator, roughly 1 per million. Good luck competing with 1,000,000. Unless you have lots of money, yes, and you want to help contribute to the campaign, then you're going to get the attention of someone at the state house. In New Hampshire, of course, as I turn over here, to mention that. But as far as representing the people of Siskiyou County, another form of representation by the supervisors would be to represent us in court. And obviously, since a lot of private money has been pouring in to support the lawsuit and fund the lawsuit, obviously people are voting with their dollars if they really want this. And of course, there's legal ramifications. I'm glad Mrs. Nixon is available to help somewhat. But I really encourage supporting this and representing the constituents in as a plaintiff. So, that's it.
Thank you. Liz Bowen?
I wouldn't mind.
Okay. All right, so we'll bring it back to the board. Let's get started down at the end, Supervisor Chris.
All right. So first, where else can you have where business logic could come up before a board and ask the question, hey, is this true or is this not true? It's just wonderful the way the government should be. And then as elected, we have a chance to answer and say yes or no, or get that, we can be held accountable, which is wonderful. I also wanted to compliment many of those that back in 2011, they were going to split Siskiyou County in half for representation. And it would have diluted us even more at that time because they were combining non-like areas with other areas along the coast. And Ms. Felice Leal did a great job getting the word out with emails. I went down to Sacramento and testified before the redistricting commission, and I wrote down Siskiyou County. And they said, we've heard from you guys. We got the word out. The 1602 permits for farmer's ditch. The California Department of Fish and Game came before us about, I think, last month. And they were telling us about the permits that are necessary. So I asked a series of questions. Is it just rivers that go out to the ocean? No, it's any river where there's a substantial diversion. And I said, so you're spending a lot of time on the farmer's ditch with the diversions in there. How many 1602 permits do we have for the Owens River? And that's the Owens Valley. When you think about China, what was the movie with Jack Nicholson? Chinatown. We have a movie there with Chinatown. One of the greatest diversions of water in the West, from the Owens River out to LA. And where's the 1602 permits? So we're spending all our time on Farmer's Ditch, we're spending all our time on the Scott and Shasta rivers for these permits. Those are very minor diversions when compared to the Owens River. It changed the whole ecology for that area. The difference is Los Angeles has 37 assembly members. And we have this. It was good for the goose, it's good for the gander. So if he pushed on us to do it, then it should be pushed everywhere else. That was one thing. There's the last presentation is amazing. This happens a lot at Board of Supervisors meetings. We'll have something that doesn't seem related at all, and yet it connects to what we're talking about next. There's a quote from the 1878-79 Constitutional Convention. It's from a Mr. Andrews, one of the delegates to the convention there. You're probably already familiar with this. That said, the other parts of the state have, from the very organization, paid tribute to San Francisco. At that time, that was the big urban area. LA didn't have air conditioning yet, so San Francisco was a spot where people were at. It is that which has made San Francisco what she is today. And I say, if representation is to be cut down, do not cut it down in such districts as I represent. I have seen in the history of this state, representatives from other parts of the state save San Francisco from herself. And I love that quote there, and I highlighted it. You look at XX'd Dam, San Francisco declared a national or state of emergency before the neighboring counties did. XX'd's over in the Sierra areas, and they had to declare emergency ahead of time because that was their water for their city. Well, we just had a presentation here. There's not proper tree management. There's not those factors. You're affecting the city, the city's water supply. Where does the great presentation there? Where does most of the water come from for Southern California? It comes from up here. With proper tree management, proper management of the forest, you increase the water supply. We're saving San Francisco from herself, away from herself. This subject really tugs at my heartstrings because I wrote my master's thesis on it back in 2008. And I love the subject. I love it. When I spoke, I had to defend it back in Vermont. And I said, senators by county pretty much, one to three counties. And they said, justify that to us. So I said, here's Siskiyou and here's Modoc. This is bigger than the state of Vermont. And it gets their attention. It gets their attention on that. You talked about it was voted on by the people. You have the original intent of the framers of the Constitution, which was not necessarily representation, it wasn't just proportional, it was geographic as well as proportional. You look at the 14th Amendment, which was used, the legislatures that passed that reaffirmed that in 1860s, did have representation in their legislatures that were geographic as well. That was the original intent. And then you have the continual intent. So you have Prop 28, 1926, and that gets voted on. It passed, I think 56 counties voted in favor of it. And then they said people didn't understand what they were voting for. They just didn't understand it, so it came back for a vote. Passed again. 1948, they said people just don't understand. They don't want this rural representation. The federal plan was, as you brought up, the assembly was by population, and no county could have more than one state senator, so LA had one state senator. Meanwhile, they had 30 assembly members, they weren't being diluted. And then no senator could have more than 3 contiguous counties. So that it spread up the rural and urban, check with the Senate and the Assembly. So it got voted on in 1948. People don't understand, not fair, federal plan wins again. 1960, it gets voted on again. 1962, you had Governor Brown, a very popular governor, opposing the federal plan. You had former Vice President Richard Nixon opposing the federal plan when he was running for governor. And then you had President John F. Kennedy, a popular president, opposing the federal plan at the national level. So it came up for a vote for the people again. Once again, the people voted for the federal plan. It was not just the original intent, but it was the continual intent of the voters. So for myself, this is a great passion. I love it. I read through this the other night. It was fun to remind myself of this stuff. Now, from the county's perspective, since I get to start first, we'll see where I'm at. For me, I can support this. As Brandon and Chris, constituent in California, I can jump in and raise the flag. From the county perspective, we do need to confer with our county council on the 3-judge panel. We also have to know the liabilities we face. I don't mean to be a wet blanket, Mr. Baird. I appreciate the fact that when you brought forward the state of Jefferson, another issue previously, that you didn't demand a vote that day. And I appreciate today you're not coming before us and saying, I demand you vote on this today. You're giving us time to think about it in the deliberative process. I appreciate that. So I don't want to be a wet blanket, but these are the questions representing the county's interest. What our liabilities are. Is there a possibility of amicus brief? What would that contribute or detract from it? The intervener, it is going to take some staff time, just because, if we put our name to it, we got to do it right. And this is a big issue with voter dilution. So those are some of the things I need to flush out. Like I said, I apologize for coming across as a wet blanket. It's not my intention.
Not at all. It's your right, your responsibility, and it's your duty, and I appreciate that and I applaud it. That's I stood before many boards and I say every time, this is the best of America. This is what Alex de Tocqueville called the greatest form of government known to man, the township.
Right.
So I appreciate that. I'd like to address one issue. The amicus brief would be extremely valuable, but it may not be required because if we don't get the 3-judge panel, there isn't going to be a case. So we need a county government to act as plaintiff in this case that will guarantee the 3-judge panel. And if we get that 3-judge panel, we're probably going to win. The only open question is, what will we win? And that's where amicus briefs and the participation of as many counties and many governmental officials as possible will help, because what the court's going to say is, okay, you win, but is this justifiable? In other words, can we craft some remedy that's acceptable to the plaintiffs involved? And the answer to that is, what do you as a county government want, and what would benefit you the most? I said in Glenn County, they're asking in their demand for no less than an assembly person for every 30,000 and equal representation in the California State Senate, which is, by the way, the tougher part of the argument to make. But because the County of Los Angeles is not going to want to give up their 11 senators in favor of one, and they are majority. That's why we have to do this in court. So the remedy is going to be open, but now's your chance to say what it is you want.
I appreciate that, and like I said, you just have to answer those questions at the county level. And thank you, Mr. Chair, for me.
Supervisor Howard.
Thank you, Mark, for bringing this forward. One of the things I think is paramount here that it was important for you to come and talk about this in public setting. Some of us are aware of the effort before, but I think it's important to be before the full board and bring that out. I'm not going to echo my colleague here. I share a lot of the same sentiments. But I do have a number of questions that I think would help us, because we do have a pretty serious deliberative process.
Sure.
That we follow with using the county's resources pending or litigation for this. So a couple questions I have is, from a comparative standpoint, do you have any idea what the U.S. House's portion is in the state population?
Yes, I do. And in fact, I have it right here. Something like 496,000 per.
That's close enough.
Yeah.
I was just looking for
Yeah.
kind of comparative.
It's pretty close to 500,000 per.
Okay. And I looked at with 40 million people in the state, using my rough calculation, it looked like we'd have about 1,300 legislators in the local house, with something like that.
Yeah, and you have a state like New Hampshire, it's got 1.6 million people, they have 400, and they manage to find, it's actually 741,982 people per U.S. House member. And at the time of the founding, the founders said that ratio should be no more than 3 times the amount of people that are represented in any state house to a federal house. So George Washington said 1 for 30 is democracy, 1 for 40 is tyranny. So I think if we got 30,000 per assembly person, actually that's not a bad day, and we could do something with
those numbers anyway.
So, the next question I have is there any kind of projection, what it, cost-wise, what it will take to take this through the Supreme Court?
Yeah, our attorneys tell us, the number always comes up, it's gonna cost you $1 million. Yeah, so far.
I think most attorneys would say that about anything.
Yeah, well, so they're telling us $1 million, so I think it can be done for a little bit less than that. Eugene Martin's working for nothing, and by the way, he knows how Supreme Court works, he's won several cases. Scott Staffney has won a couple of cases in the closed docket, in other words, cases with no arguments, where everybody submits their stuff, they read it, and then they rule. Gary Zerman's our federal attorney. These two guys are working for half right now, and Eugene's working for nothing. I think we can finish this up for a little under $750 is my projection. And we've raised about 200 so far. We already have enough money to get through federal court, I believe.
Do you have any idea?
I've got a low blood sugar.
Anomaly in California, or whether this is relevant?
Well, actually, we are an anomaly in California because we have the worst representative ratio in the United States of America, and it's 3 times worse than state number 49, which is Texas. So at 1 per million and 1 per half million, I think you have to go through about 30 states before you even get to 1 per 100,000. So we're definitely on the back end of the drag bucket, as we say in aviation, and going downhill fast. And I have the projections for the next 20, 30 years. And when we take a look at, say, 2050, we'll be at 1.6 million per state senator and one for about 750, 800,000 per assembly person. Now, Siskiyou County is not adding population that quickly, are we? So we can assume that our representation will be diluted further in order for more populated areas to gain the representation that these ratios will demand. It's not going to get better. It's going to get worse.
So could you maybe project forward, maybe a process in your mind, a timeline on how to pare this down to what the final camera-ready petition might look like?
In other words, the complaint itself.
Yes.
The complaint itself, really, the best causes of action in the complaint, in my opinion at least, are abridgment, first of all. Because abridgment is prohibited by the 14th Amendment, it's prohibited by the Federal Voting Rights Act, it's prohibited by the California Voting Rights Act. So abridgment of representation due to ever decreasing representation in any given place for any given group of people is, to me, the best cause of action. Dilution of vote comes in probably a close second, where you have a situation where person A has a vote that's worth 1, and in 50 years it's worth 0.5, and in 75 years it's worth 0.2, and on and on. And one thing I did point out to the attorney, the Supreme Court attorney, is if you squint and look down the road, you can see a situation where a group of people will have all the representation, the rest of us will have none. And the Forest Service illustrated that. Here you have 7% of the population that have to actually live in and next to these forests. In other words, we're the ones our houses are burning down when the forest catches fire. We're the ones that lose 2 billion board feet of marketable timber and have to look at the aftermath for the next 50 years. But yet 93% of the population has not only a significant part of the representation, but the majority. And illustrative of that is the Glendale State Assembly person who just introduced AB 975 or 955, where wild and scenic rivers are now going to have a quarter-mile buffer on either side of them, and he targeted the Scott and the Klamath Rivers. Those were 2 rivers specifically mentioned in a bill from a Glendale, a Los Angeles County state senator. We have another Los Angeles state senator that authored the bill for the Indian Gaming Casino in Wairika, California. And in his speech on the Senate floor, he said, hey, nobody's against this. But he didn't look at the plebiscite that we had here, and he never asked any of us. That's what we can look forward to if we don't act.
So how long do you think?
Well, we'll file this, like I said, it's going to be filed in the next probably 30 days, regardless of what action the county takes. We hope that you'll be affirmative, but if you're not, we're going to file it anyway. You get to federal court pretty quickly, 6 weeks, 8 weeks. Another, say, 8 weeks for the determination. That's a total of 16, 20 weeks, say.
I was just looking for the bring it down to the 35 pages that you.
Oh, I'm hopeful that's gonna be done in the next 14 days.
Okay, thank you. And then, one other thing, what I'm wrestling in my mind, to be blatantly honest, is if we reapportion, say we're successful and when you get to the 1 to 30,000, aren't we gonna just get more of the same?
You know, and
More, I mean,
in my opinion, we won't, and here's why. When you have a legislature that, in a sense, when you have a legislative district that, in a sense, represents a community, it takes party out of it, doesn't it? Because all too often in this state, party politics pipes the tune. In other words, if you're a member of this party, you get so much money at the beginning of the election cycle, and that goes in your war chest on the state level anyway. And if you're a member of that party, you get significantly less, and Tom Donnelly outlined all of that in his affidavit. When you're elected to your office, if you're in the majority party, you get a big office and lots of staff. If you're not in the majority party, you get the closet, you get a secretary and a dog with 3 legs. That's the way it works. It isn't good or bad, it's just the truth. So I think with representation, and that's why in my demand, I want one for 3,000 or 4,000 or 5,000, something like that. Because if I had a representative for, say, Scott Valley, or for the greater Wairika area, or the Copco Iron Gate contiguous area, party wouldn't matter to me. I would know the guy, I'd know his reputation, I know what he stands for, I would know what his positions are. I don't care about his party, I care whether he does the right thing. And he wouldn't care about his party because he'd know that he has to look at 2,000-3,000 people that look exactly like me every time he goes out in public. So I think it would take the party out of it, and it would suck the money straight out of the politics. I mean, you wouldn't need $1 million to run for office. You couldn't be bought if all it cost you was $5,000 or $10,000 to run for office. It would be very difficult to bribe a legislator when, quite frankly, he can gain a seat just by doing it the right way. In New Hampshire, they fill the car with gas and they go knock on 3,000 doors. And if they don't do a good job, somebody else does the same thing the next time, and 40% of the time or 30% of the time they get rid of them. So I think party would be a lot less important if we could do this.
all right, thank you. And I'm gonna look forward to reading now that I have the actual statutes and court cases, I look forward to reading.
Okay, and there is so much more, and if you're open to it, I'll send you all of it.
Well, I hope that you submit, as part of the record, the representation fact sheet
I will.
that I saw and
Yeah,
some of this.
I'll submit the benchmarks, and I have those all right here, so.
Thank you.
Supervisor Nixon.
Mr. Baird, thank you so much for coming today. And I really applaud the efforts of you and your group, everyone who's contributed to this effort. I know it takes a lot of money to get to this place. And I echo what our other 2 supervisors have said. This subject is dear to my heart. I have some ancestors who settled here in Siskiyou County who were involved in these types of efforts in the past. And so the subject matter is, I absolutely support. I think some of the logistics might take time to work out, but, and then I'm glad Supervisor Chris made the distinction between what we feel in our hearts and what we need to do for the county. So I know that the question is whether to be from a plaintiff or not, so I have a couple of questions that I'm not clear on. With regard to the 3-judge panel, I'm reading 28 USC section 2284 and section 1253, and there's, to get to that 3-judge panel, and I'm not seeing any requirement that a county government has to be involved.
No, it doesn't. That's not a requirement. What it does is it makes it harder for the federal court. In other words, the federal magistrate, when you walk in the door with the filing, has all the power. He can decide that the case is frivolous and without merit and dismiss it with prejudice. Just like that. And at that point, we have to go to the 9th Circuit, and now the money comes out in years and years, and quite frankly, we probably wouldn't prevail because I don't think we have the financial horsepower to keep up with that. And in the 9th Circuit, you probably wouldn't prevail anyway. So, and we know that. So what the county does is lends credence to the suit in order to say to the federal magistrate, this case has merit. And once it has merit, he has to apply to the chief magistrate for a 3-judge panel. The only reason we really need the county is to make sure we get that 3-judge panel.
Well, or to make sure that the suit goes forward.
Exactly.
Doesn't get on a demurrer.
Right.
I think I need to look at that further, I think, because I know that amicus curiae briefs, which is something that we do frequently after much debate, they can be very effective if they're done properly, if new matter is given to the judge, and if the court is not besieged by a whole bunch of amicus briefs that say the same thing. And it needs to be a well-coordinated effort. So to move us to this next step as plaintiff, I need to look at that a little bit more, and I think we would ask our counsel as well. The issue about indemnification, in the event we do get hit with attorney's fees, as you know, our budget is very tight, and we have a lot of litigation matters that we have to be involved in. And I know this is very important, and you've represented that the nonprofit organization would be able to indemnify.
I've already discussed this with the board. They've already taken a vote, and they voted in support and to affirm the fact that we will indemnify the county against fees. And if it makes you feel more comfortable, I'm fine with county council writing that paragraph.
My concern would be that there is a pool of funds available, either to securitize or actually.
Well, I think you could probably agree that if, in other words, the Voting Rights Act is pretty clear. A case has to be frivolous and without merit for fees to be assessed. Once the demurs are over, in other words, once we make it to court proper, the state will lose its right to ask for fees because obviously the case has merit or it wouldn't be in court. So if it's dismissed, it'd be dismissed on the demurs, then we have a choice to make, and those fees will be relatively insignificant compared to the overall scope of the case. So we could very easily indemnify the county, and we have the funds to do it.
Yeah, I think if we can just validate those funds, and I think we can start.
Yeah, you got bank statement or whatever you need.
And then finally, my final question is, and this may be a matter of procedure, which I'm not familiar, but I'm not clear on if each one of the plaintiffs makes a separate demand or a prayer for relief that is a different solution to the problem. Doesn't that weaken our case? I mean, once the court decides, yes, we'll let you reapportion, now you're leaving it to us to figure out?
No, actually it doesn't, because the demand process itself, it has little to do with being a plaintiff. In other words, I've already filed my demand with the Secretary of State. I have no representation. I demand that the state of California rectify this situation, and the way in my mind you can rectify it is with a state senator for each county and one assembly person for every 2,500 people. So that's the letter that I wrote to the Secretary of State. It's been recorded, it's been served to him. Each plaintiff will come to the table. For example, Shasta Nation would like to see representation such that at some point in the future they can hope to gain a seat in California's assembly. So their demand is different, their needs are different than mine. That doesn't weaken the case, because what we need to do to make this case is we only need to do one thing. We only need to get the defendant off of the point where they say 40 and 80 is the only way to run this state. The minute they vacate the 40 and 80 position, the door is wide open. And quite frankly, a lot of that may be resolved in a settlement conference. In other words, the judge says, look, California, the folks here have a good case, and you better figure something out. So go in the back room. And that's where folks like yourselves participate as plaintiffs, and you have a seat at that table to say, look, a county cannot function unless we have a say in apportionment legislation, which you would need a seat in the assembly, and unless we have a way to counter the unbridled mass of people that come out of the urban areas, and that's why you need a seat in the Senate. Those checks and balances work. And in that settlement conference, I'm sure that will be determined. In the case of West Virginia versus Virginia, the court was willing to settle West Virginia's debt, but then they said, it is beneath this court for us to argue the details. You all go in the back room and figure out how you're going to settle this thing. And that's exactly what happened. So no, actually, plaintiffs having a different demand helps us, because what we really need to do is assail the state of California with so much factual information that 40 and 80 just does not work. And I think even sitting legislators agree with that. Brian Daly said so. He said one size fits all doesn't work in my district. And so if we get them off that point, 40 and 80, now the door is open, and it's up to us to craft an equitable solution that works for everybody.
This could be a historic time for us.
I hope so. I'm praying for it.
Thank you.
Thank you.
Supervisor Valenzuela.
You know, in theory, just like the state of Jefferson, you know, I get that. You know, more from a practical term, this is all new to me because there was nothing in my agenda packet. And it asked me to do something that was really foreign for me, is to start suing people, right? To look at our closed session items and think how much money we spend resource-wise and those kind of things. And, you know, my district is a bit of an anomaly. You know, it's probably the one 96067 has the most Democrats. And so they're probably thinking of this from a different plane. And I do represent constituents, as you might imagine. I'm not sure that flies with what you're trying to do. I think over a cup of coffee they might get it. But, you know, they would say that we're my district's on the short end of a 4-1 vote more often than not in Siskiyou County. So let's do it on a local level and see how it plays out. I don't know. It's all information I would love to look at. I love history anyway, so I don't mind looking at those kind of things. And one thing I've learned is never to say no, but not like it.
Okay.
For me.
So I guess a couple things from me. You've heard me all throughout my time as being elected is that, you know, for me, the cure is the one senator per county.
Sure.
I mean, that's fair representation and it cure
Makes sense.
the ills of the California legislature overnight. If that could ever happen, I'll cap it that way because that way there's representation. There's a couple of bills that will be going before initiatives next year, where the state legislature is crafting as we speak, that county supervisors, city council members would have to be partisan offices. And another initiative that would make school district electeds in partisan offices. You know, I have always advocated that, you know, another cure to government is that partisanship should be gone at the state and federal level. There'd be a lot less hassle. And now, you know, they're crafting a way to make us all partisan. It's beyond.
They tried that in Soviet Russia, and it didn't pan out for them.
But I think what we would need, actually, Mr. Baird, is the final of whatever it is that you're proposing. It sounds as though it's still in draft form.
Well, the only reason it's in draft form is because I haven't asked the county to join it. The minute I have the word, whether a county is going to join or not join, as an original plaintiff, they can finish that complaint in a day.
Well, but I think
Yeah.
we need to see more of a final version.
I'll tell them to
contemplate
finish it now.
So that would be more helpful than just seeing something in a draft form.
Okay.
And I think you know, at this juncture, I think I think each of the board members are willing to take a look at that. I think that we'll take it under advisement at this juncture. But I don't want to waste resources, I guess, on chasing a draft copy. We would need to see something final and finale.
Well, I will instruct the attorneys to finish that complaint, and they'll have it finished by Friday probably, so I'll try to.
For us to review.
Yes, absolutely. Yeah, so a finished complaint, indemnity agreement, or do you prefer county council would draw that up if we get to that
If we
point?
get to that point, I think that's a different subject.
Okay, that's
as
fine.
we get to there, but I think we just need to see something in.
How is it best for me to prepare all of these materials to submit to you? The complaint's 57 pages, my home copier. I need to get packages so that everyone has all the information they need.
Yeah, if you bring it in, we can scan it and
Yeah.
distribute it.
Okay, so what I'll do then is electronically prepare those packages with these benchmarks and the complaint and so on and the proposed resolution. But once again, that's an open frame document, and everybody that gets one just changes it to whatever they feel is most appropriate for
Understood.
for their needs.
Understood. It'd be better to look at something that's not a moving target.
Sure, absolutely, and I agree. Thank you so much for your time. I appreciate it very much.
Okay, thank you.
Thank you.